And we're live. We're live. Awesome sauce. Let's make sure that everyone can see us. And I'm going to give it just a couple of minutes because I know that there is a little delay between the live and the broadcast. Let's see. Just make sure. Okay. Let's get back to. Hey, Rico, good. You see me good. You see me good. Awesome. That's what I want to make sure. And are you watching directly from YouTube, Rico? Is that where you're? Or are you on the page? And ignore this huge pimple on my forehead. Let's see. I'll put my notes up. Oh, I have my notes. So I want to be able to see my notes with the questions on it. And I want to be able to see the comments. Perfect. All right. Perfect. Well, let's see. We're going to wait one more minute just to make sure. Oops, this is not my notes. See, that's what happens when you have all these tabs and different work. You end up opening the wrong thing, which I want to see if this is it. Nope. Keep opening the wrong thing. Found it. Awesome. Okay, so tonight, yay, we have Miss Trinity Infinity on. We have Mr. Rico Macadori on. Awesome. So we got some really good questions. We're going to go ahead and get started. So for everyone that's watching, if you're new to me, if you're new to my channel, if you're new to the Genius Lounge, you're like, what did I sign up for? My name is Attorney LaConya Murray. I am the owner and founder of Off the Mark IP Solutions, where we help clients throughout the United States own their genius by helping them protect their brand through trademarks, copyright, and business development. And another way that we do that is we created the Genius Lounge, which is a community for ambitious entrepreneurs who are looking to have a steady foundation in business and law and have a community around that. Because we need a place to hang out, right? So come on over to the Genius Lounge. It's free, by the way, and you have access to things like this, which is weekly Q&A. We also have our Genius Insider program for those who want actual access to an attorney on a regular basis. The Genius Insider will allow you to have free consultations, document review, and other access such as master classes. So this here, because we have the two programs, the questions that we have some questions that were submitted. The questions that were submitted by the Genius Insiders will take priority. And if we have any other questions from the Genius Lounge members, those will be next. And then finally, if we have any questions that are submitted live, if we have time to get to them, we will get to them during the live broadcast. We're here till 7:30. All right, so let's get started. First question. Oh, you know what? Before I get into the questions, y'all probably like, what is going on? So, Murray's Law. Little play on words, right? So Murray's Law is your opportunity to ask me questions relating to legal or business, and I will answer them, just under the caveat that, excuse me, under the caveat that this is not legal advice, is what I'm trying to say. All right. Yay, Diana, you made it. Yes, you said I am old school and I didn't even know how to connect. So here I am on YouTube. Hey, YouTube is fine. That's where we're streaming from. And I will figure out how to allow comments on the page. We'll figure out that tech for next week, right? Because this is a weekly thing. So Murray's Law is weekly. We come here Mondays at 7 o'clock for 30 minutes. And we talk legal and business. So yeah, that's what we do. So let's get started. The first question, get this out of the way. Here we go. So our first question, it's a really good one. They want to know, what are the types of agreements or contracts that someone needs in order to get permission to use content, image, audio, or video from a business or a person on the web or print physical limited copies? Really great question, and you can look at it from two ways. So I'm going to answer it. So you can look at it from the point of, you hired someone to take pictures, right? To model for your website or something of that nature, and you want to make sure that they can't come back and say you can't use those pictures on your website. Or maybe you hired someone to speak at an event, and you want to be able to use a portion of their content, or a portion, use their likeness in your advertisement. That's one way. Or maybe it's something you saw on the internet and you're like, oh, I want to use that picture. Oh, I want to print this. I like this blog post. I want to print it and pass it out. Or I found a copy of a book online. I want to print it, and pass that out. So what are the circumstances surrounding that? So we're going to start with the first two. Basically, you're working with someone and you want to make sure that you have their permission to use their likeness, because at the end of the day, when you're talking about using someone's image or even audio from a video, you're talking about using that person's likeness. So, and although, likeness isn't technically intellectual property, more and more courts are starting to recognize the importance that people have in their likeness, because a lot of people, they make their money from their likeness, which is called right of publicity, right? So right of publicity is not federal. It is decided state by state. And in those states that do have some sort of law enacted, essentially what it says is that you can't use someone's likeness for commercial purposes without their permission, which makes sense, right? Like, you would hate to be walking down the street one day and see your picture on a billboard and you're like, wait a minute, how'd that get there? I'm not getting paid for that. That's the first thing you think, right? I had a friend that I went to high school with, and he swears up and down that Huggies used his picture on their box for their Pampers. It do kind of look like him though, but I'm sure that they didn't do that. But so you want to use what's called a model release form. If it's a person and you're talking about pictures, or even video, you want to have some sort of release that gives you permission to use their likeness. And then in that, you can negotiate on what the restrictions are, or what the use looks like. For some people, it could look like you have full use, the model doesn't have any say on how you use it, or there could be a limitation that says you can only use it for what's the word I'm looking for? Like for PG purposes, right? Like, you can't go and alter it in any form that shows the person in an unflattering light. So that's one way of looking at it. The other thing is, it says permission to use the content. When I'm thinking about, and you know what, let me just back up. I have another example for you all. When you're thinking about, you know what, there's another question. There's a part 2 to this question, so I'll hold on to that, right? I'll hold on to that. But when you're talking about, which camera am I looking in? I got 2 cameras up. I don't even know which one I'm looking in. But when you're talking about content, now you're moving into intellectual property, because content is, and then even images, depending on what type of images they are protected by copyrights. Copyrights protect original works that are in a fixed, tangible form. So it can be a blog post, it can be a video, it can be a picture. When people are building websites first thing they like to do is search the internet for images and then right click and download and then save that image to their website. You can't do that. You can't do that. You can't do that. Like, you can't do that. That is copyright infringement, because the person that created that work has a say-so in how it's used. That's what one of the things that the person that owns the intellectual property, they have a right to say how it's used, right? So it's, for example, when you're talking about printing limited copies of something, because the person that wrote it has a say on how it's used, because that's how they make their livelihood. Just think about if you had authors who were writing books and people were just downloading their books for free. Or you remember when, what was that, Napster? Wasn't that Napster, that music pirating site where people, CDs would come out and then Napster would get it before they came out? So that's pirating. Those artists were losing money because people were downloading the album for free. You can't do that. And some people say, well, I wasn't charging for it. I just want to share it. That doesn't negate the fact that this is how people eat. Or this is how artists and creatives eat, is by creating. So no, you can't download the things without their permission. So in order to get their permission, let's say it's someone that you don't know, you need to reach out to them in order to get permission. And let's see, what is the cost for legal services to review and create releasing? Oh, Zachary, you are an insider, so you get free document review. So if you go to your insider benefits and just start there. Start with the insider benefits so that you can fill out the form and upload the document, and then I'll review it, and then we'll go from there as far as what you may or may not need. So that's good. And Zachary is actually the person that asked this question. When it comes to limited, like getting permission, you in contracts, one of the things that you can do is get a limited license. You can have a limited license to use someone's likeness for a certain reason, or use, print a certain number of books or something of that nature. A license is just a permission to use, because remember, the person that owns the copyright has the right to say how it is or is not used. So if they want to give you permission, they can give you permission. It doesn't have to be exclusive permission where you're the only person that gets to use it. It can be non-exclusive, meaning that other people can use it. And then with that limited license, they really limit exactly, like they're really detailed about how you can and cannot use whatever it is that you're trying to use. So as far as documents, to just recap, you can use, if it's someone that that's doing something for you for a project that you're working on, you can use a model release form. If you're having an event and you want to make sure that you can use the speaker's likeness and part of their content, put it in a speaker release form. Or if it's something that you want to use off the internet. So another thing too, on the internet you can find, so when you're looking at these images, you want to know what type of permissions you have. So again, license that you have. Some have commercial, you can use for commercial purposes, meaning that if you want to use that image or font, because fonts are protected by copyright. So this is really important for everyone who's out there creating journals, that's graphic on the front, or t-shirts or anything. Fonts are protected by copyrights. And when you're using these fonts, you want to make sure that you have a commercial license to use it, meaning a lot of fonts let you use it for personal reasons, meaning that you type in a paper or something of that nature. But when you take the font and you start making money off of it, you could be in violation of that license. So licensing agreements is another way that you can get permissions, and they dictate what those permissions look like. Great question. The second part of that question is, what does fair use mean? So fair use is essentially an exception to the copyright rule that gives the owner the rights to exclude other people from using their work. It says, you know what? If you're going to use this work in a certain set of circumstances, you don't need permission of the owner. And that gives you permission to reproduce it, make copies of it. But those reasons are really, really limited, right? So you have purpose for criticism. So you see a lot of these think ed pieces, think pieces, where something will happen, like a song will drop, and then someone will write a whole dissertation on what the song meant, right? And then they'll include lyrics from the song. Any other time, those lyrics will be protected by copyrights because you're using it to criticize, right, or comment on. Now it's protected by fair use. In news reporting, the news people that report the news can also reproduce copyrighted material. Teaching, so if you're in an academic setting, and I mean a true academic setting, not necessarily, the course industry is now $1 billion industry, so not necessarily for your course, for your business, but if you're in an actual classroom setting, then that's an exception. Also, scholarship or research. They don't consider those uses copyright infringement. But even if you're using it for those reasons, that doesn't give you the right to take advantage of it. They do have like 4 factors that they look at to make sure that it's actually fair use. The first thing, they're going to say, what is the purpose? Why are you reproducing this? What's the purpose and character that you're using this work for? So, like, is it for criticism? Is it for scholarship or research, or for teaching? Is it for any of those things? They're going to look at that. What's the nature of the copyrighted work? What exactly are you criticizing? That matters as well. And how much of the work did you take? And what does the effect does it have on the market? So again, if you are using this for criticism, that doesn't give you the right to reproduce the entire work and distribute it, because now that's going to affect the market. When they talk about potential market, they're talking about, is somebody losing money because of this? One of the cases that I was going to talk about earlier, when it comes to fair use, a lot of people say, well, I'm only going to use a little bit of it. I'm not going to use a lot of it. I'm just going to use a little tidbit of it. And Beyonce, a few years ago, I feel like time is going by so fast. Like, when she did the Lemonade album, she was sued by, now I can't remember the person's name, Maya's estate, because she used a part of his voice. So she was sued basically for copyright infringement and right of publicity, because that's his likeness, in his voice. And her defense attorneys wanted to throw the lawsuit out, and the judge said no. They wanted to throw it out because they only used like less than 6 seconds of his content, and they said, oh, that's not enough to count. Well, that's not necessarily true. They're going to go back and look at these 4 factors: the purpose that you used it for, the nature of the work, how much did you use, and what's the effect on the market. They're going to run it through that test, and that's not something that you can just judge off of 6 seconds. What if the work was 10 seconds, right? So they wanted to do an overall assessment of the infringement. So thank you so much, Zach, for the questions. I hope that answered your question. And give me a second to adjust my camera, because it feels like, there we go. So it just feels like it's not really getting on me. All right. The next question we have is, when can you apply for a trademark? When can you apply for a trademark? Here's the deal with trademarks. So trademarks protect brand identifiers. Those are those things that tell you the source of a good or a service. And when you have a mark that's letting you know the source of a good or a service, then you have a trademark. So you don't have to apply for that trademark, is what I'm trying to say. Like, that trademark is automatically attached from the time you actually start using that mark associated with a good or a service. Now, you want to apply for a federal trademark in order to strengthen your protection, because right now with that common law, it's called common law use. When that common law trademark, your protection is limited to your geographical area where you do business. whereas your federal trademark allows you to prevent people throughout the United States from using your same or similar mark. So think about, maybe you are in a small town and you sell there, but then you also want to start shipping into other states. Well, if you don't have a federal trademark, when you get ready to expand into other states, you could run into the problem that there's already a trademark, someone using that name in another state. Or this is something that I see quite often, where people will say, well, I'm not getting a federal trademark, I'm only operating in my state, so I don't need a federal trademark. So they don't get a trademark and they don't do a trademark search or anything of that nature. However, there's someone in another state that does have a trademark. So even though you're not worried about protecting your brand, somebody over here is, and you could be infringing on their trademark. So to answer that question, when can you apply? Again, you don't have to apply for a trademark, but once you start, because you have that automatic right once you have a mark associated with good or service. But once you have a trademark that's associated with a good or a service, and that product or service is available in multiple states, then you want to start looking at applying for federal protection. Great question. Those are the 3 questions that were submitted, and we have a few more minutes left. I see Kickstart with Ann. How you doing, Ann? Let's see. I edited photos from Pexels for my book covers, which says the photos are free to be shared for commercial use. I'm planning to do my own photo shoot to eliminate anyone coming after me. You know what, Ann? That's the perfect point. If you want to eliminate any confusion, create your own. That's why intellectual property is so valuable. That's why it's so valuable. That's why we need to get in the habit of creating our own work. So that's a good thing. And so, Ann, when you do this photo shoot, if you are using third parties, I don't know if you're just using yourself as a model or if you're going to use a third party. But when you use a third party, make sure you get a model release form. And give me a second to grab some water. And make sure you use a model release form so that you have permission to use that model's likeness, and they can't come back and if they change their mind and don't want to be associated with the project any further. And I actually have, I think I have a model release template in the Genius Lounge, in the Genius Lab. So the Genius Lab is our online store where you can find books related to trademarks and business. We even have a business plan workbook, contract templates, and courses. So you can go to the Genius Lounge and find all of that. Rico says, in terms of copyrights, I'm hesitant to play music of others artists via Facebook or YouTube. If I play music on Facebook or social media, it will be my own music, as it should be. And Rico, you bring up a good point, right? Because I see it all the time where people are playing music on social and they put this caveat that says, I do not own the rights to this music. So let's go back and recap just a little bit. We said that copyrights protect original work that in a fixed, tangible form. Music qualifies as that. We also said that the owner has the right to basically say when and where this work is displayed. And that if they didn't give you permission, that's copyright infringement. So when you say that this is not my work, but you're going to play it anyway, you're essentially saying, hey, look at me. I'm stealing. I'm stealing. I'm stealing. And that's not a good look at all. At all. All right. Well, good. Ann says she's going to be the model. That is the way to do it. Perfect. Oh, but there's something else. So copyrights have layers, right? So even if you are the model and your photographer, as the person that's bringing that to life, so your photographer is actually the person that's creating the work. Because they are the person that's bringing what they call the author, the person that's bringing it to life, the photographer will actually own the copyrights to those photos. So you make sure you have a conversation with your photographer beforehand that you won't be able to use those pictures for commercial use, and get it in writing. So yeah, there's so many layers to intellectual property. Let's see. Cool beans. We have about 5 minutes left. This was a really good session. So I know it's been a while since we did a Murray's Law, but I like this. I'm actually streaming live on YouTube for the very first time. Woot woot. But if you are watching from YouTube and you're not a part of the Genius Lounge, please go check it out. Go to geniuslounge.co, which is .co. It's a free community where you're able to ask questions like this, interact with other business owners. You can even buy different things to help you along your journey, contract templates, books, things of that nature. We also have some free resources there as well. And if you're looking for an attorney to help you with trademarks, copyright, and business development, join the Genius Insider. The Genius Insider is our paid legal it's legal and business membership program. That's what makes it different. Usually you get either legal membership or business membership, but this one is both. And so with that, you get free consultations, you get free document review, you also get access to monthly masterminds, hot seat opportunities, and just an opportunity to network with an amazing group of people. Enrollment is closed right now, so you want to join the wait list, but we will open up enrollment again at the end of December, but it'll only be open for 25 people. So just make sure if you're interested, make sure you keep an eye out for that. All right, are there any other questions? Let me check. I got one more place to check for questions to make sure I have them all. Oh, someone had a question about a post that I did a few weeks ago. I don't think it was a few weeks ago. Let's see. Oh, I guess it was a few weeks ago. Right before Thanksgiving, I did a post talking about the fees that are increasing with USPTO. So if you're going to file a trademark, you need to go ahead and do that now because the prices are increasing on January 2nd. But some of the things that they didn't understand what I meant. So let's talk about that. Let me go through and see. So they didn't know what I meant by, the question is, what do you mean by post-registration fees? Like, what do I have to pay after I get my trademark? After you file your trademark, there's a couple of different things that you have to do. First of all, your trademark doesn't expire. It's good for as long as you use it. But USPTO wants proof that you're actually using this mark in commerce. So we have what you call maintenance. The first maintenance is due between year 5 and 6. And so the fee associated with that is increasing. I think it's increasing to $450 if I'm not mistaken. I don't have those fees on me, but I think that's what they're increasing to. Then you have other fees. Let's say that you need to do an assignment, meaning that because your intellectual property is collateral, it's an asset, right? So you can use it as collateral. And let's say you need to assign your intellectual property to someone for collateral. I see this all the time with the companies that are using it and assigning that work to banks, or maybe you're changing ownership. The fees associated with that are increasing. There's different forms and stuff that you might have to do, and those fees are increasing. So that's what we meant by that. Let's see. All right. Well, thank you all for joining me for our first Murray's Law of December. And if there are no other questions, we are going to end this. I'm losing my voice. I got to get my voice back right. Get back into training with that, right? So I'm just checking to make sure there are no further questions. One other place to look. Refresh this. Okay, those are all the questions. Really great, really great. So you guys can go ahead and you can keep submitting your questions on those same forms, and I'll just go there next week to pull more questions. So over the course of the week, if you think of something, just drop it in. Okay? Y'all have a good night. Possibly, if I can figure out how to... There we go. Thank you. Thank you all for joining. You have a good night.